confident we will soon see the end of this last mile marathon effort.
Hello and welcome to ViEUws.eu and our leading policy interviews. Joining me today to talk about safe harbour and data protection is the European Data Protection Supervisor, Giovanni Buttarelli. Thank you very much for being here. Well, let's start with the GDPR, the General Data Protection Regulation. Trilogues are ongoing and there are 3 different proposals on the table. You maybe have a 4th way. How do you see those negotiations progressing at the moment? I'm
quite confident, though I'm not present in each of the relevant steps, but of course we follow closely the trilogue. I've been appointed with a specific recommendation to be proactive, and this is why I refrain from adopting a long document by focusing on specific recommendations where we focus on what is positive in each of the 3 versions by Commission, Council and Parliament. I cannot say I'm closer to one of them, but I deeply recommend we squeeze the number of legal provisions. This is why from an average of 28,000 words we move to 20,000 words. And what I see is the need to, in line with the judgment now on the safe harbour, to entrust DPAs with the power to issue guidance, best practices, recommendation, instead of fixed rules within implementing acts. I'm confident we will soon see the end of this last mile marathon effort.
Do you think they're going to meet the deadline by the end of the year?
Yeah, it could be January, but I'm sure under the Christmas tree we will celebrate something.
Turning now to the less talked about instrument, which is the Data Protection Directive as it applies to law enforcement. It hasn't got nearly as much attention as the regulation. Do you see a reason for that?
Of course, the attention is largely on the regulation, but institutions continue to deal with the reform as a package. I will adopt, right after the Council decisions, an opinion on the directive. I would like to see the synergy in between the directive and other existing tools, such as those around the umbrella agreement.
Well, we're going to talk now about the umbrella agreement. It has been described by some people as leaky. Do you think that's fair?
It's much more positive than I expected. I expect some maintenance and a proactive approach. What is essential is that we focus more on the reform, and the umbrella agreement should be entirely consistent, should represent a framework picture as a point of reference for any future bilateral exchange of data.
Well, now, under this umbrella, what the European Commission has sought to find is that EU citizens will have the same rights as US citizens, so the right of redress should their data be mishandled. There's an implication that that's going to be a panacea, if you like. But things are exempt under the US privacy law, such as PNR, passenger name records. This PNR data, it's quite serious, isn't it?
It is, particularly now after the new judgment from the Court of Justice, which is to be read together with other 2 on the jurisdiction of the national DPAs and on transparency. So proportionality and necessity are not simply recommendations or best practices for our legislator. They are strict requirements. I would continue recommending the legislator to more selectively focusing on targeted actions concerning specific categories of flights, passengers or countries.
Well, this is because the idea that blanket data retention was struck down by the ECJ, and blanket means sort of indiscriminate, huge amounts of data being stored. There is now the proposal on the table again for a European PNR. What's your view on that? Do you think that would stand up to a legal challenge?
It's up to the legislator to evaluate necessity, but let me speak now for a second as a member of the judiciary with a solid background on anti-terrorism and anti-mafia legislation. If you speak with colleagues taking the lead on these issues, they would really appreciate specific actions instead of large-scale databases which can be used perhaps twice a year.
Finally, you have proposed the setting of this new ethics board. What exactly is it, and what will it do, and who will be on it, and how will you choose who is on it?
Oh, that's the investment of the year. This is why around the data protection, and I would like to land with the announcement of the board. Of course, we will be entirely transparent and objective. I'm working on an idea to have a small group, but working within layers, meaning interacting with many other people by hearing different voices, not necessarily privacy friendly. The idea is to complete this exercise, at least the preliminary phase, within 18 months, and to have an international event by the second half of 2017.
And the idea that they will provide insight or feedback to help the EDPS office in its duties?
That's a challenge, because to have an advisory board within an independent institution is relatively new. But I think this is an important exercise, since rules such as those in the GDPR are essential, but they are not enough. The new chapter on data protection should build on a new reflection on the ethical dimension.
Okay, thank you very much.
My pleasure.
That's it for our interview on data protection, but do stay with us on ViEUws.eu, where you can see other interviews and, of course, our Brussels briefing on tech, as well as a full debate on the digital single market strategy.